The broadcast is now starting. All attendees are in listen-only mode.
Hello. Hi. Hopefully you can all hear me. If you can't, let's see, there must be some way to contact me. Anyway, you can always ask a question. At the end of the program, we will have hopefully some time for questions. And I think what you do is you type them in, and then hopefully I will answer them or know the answer to these things. Let me quickly introduce myself. I am William Gamble. I am a consultant with ITG, which doesn't tell you very much. I've been practicing law for more time than most of you have been alive. Mostly securities, tax, banking, you name it. I also have 4 IT certifications, and I teach the privacy and cybersecurity laws, and also ISO 27000 lead implementer and lead auditor. Anyway, what we're going to talk about today is cybersecurity laws and privacy laws. We'll get to that in just a second. First of all, the words from our sponsor. This is what ITG does. ITG's claim to fame is that it is the first company ever anywhere to certify to the ISO 27001 standard, although it wasn't even ISO 27001 when they got certified. It was started out as a British standard and didn't become ISO standard until 2005. And this is the various types of things that we basically do, is help people certify to various number of ISO standards and other cybersecurity types of standards. However, that's not what we're going to deal today. Today we're going to deal with more of a legal type of thing. We're going to deal with this. Well, we're going to deal with various types of cybersecurity laws and what has happened over the last. I've been writing about international legal infrastructures for the past. Since about past 20 years. I've written books on China and most emerging markets utilizing concepts of law and economics. And what I noticed is a part of globalization is you have globalization of laws as well. So quite often a successful law will be copied by countries all around the world. It doesn't mean they will be enforced the same way, but they are very similar. Now, normally this process can take decades. What's happened recently is that the concepts of privacy and cybersecurity laws have exploded, and the process is now taking months. So what is happening in this area is just truly impressive. And the California Consumer Privacy Act is just one indication of a much broader trend. So we're going to talk about types of cybersecurity laws. We're going to talk about U.S. laws. This is not a seminar about the GDPR, although I will refer to it. You will find out, hopefully, if your organization needs to comply with the California law. And then we'll talk about the levels of penalties. And the levels of penalties is potentially will make the penalties associated with GDPR look like chump change. And then I'll talk to you a little bit about global compliance, because I've also done surveys of the 20 or so countries now. I mean, it increases every day, of countries that have adopted laws similar to the GDPR. And we don't want to go around and conform our if you're a truly global company, and a lot of my clients are, I don't want them to make difference. It'd be better if we could have a one-size-fits-all solution, which I think is definitely possible. Anyway, so first of all, let's talk about laws in general. The real problem with cybersecurity and privacy laws is that laws have borders. So in an American law, it doesn't work in Canada, it doesn't work in France, and it doesn't work in Japan. It only works in the United States. But the problem is that the internet doesn't have borders, okay, because that stuff goes everywhere. So the real question is, how do you protect your citizens from an international internet that originates in other countries. I mean, that's what, fortunately, I must admit, provides us all with lovely jobs in cybersecurity, is that there are countries, I won't name them, but there are countries out there, God forbid, that don't enforce the cybersecurity. In fact, they sort of encourage their citizens to steal other people's junk. As long as they don't steal their citizens' stuff, they don't mind at all if these denizens of these countries go out and steal other people's junk. And so you really have a problem. You have sort of, rogue countries out there that are sort of encouraging, violation of law. And then how do people like in the United States or in Europe, Japan or South Korea or any place like that protect their citizens from, problems with both cybersecurity and privacy? So there's always a question of jurisdiction. It used to be really simple. If I killed someone in New York, I'd be tried under New York law. But the problem is, what do you do if, you're a company and your customers are not where you're based, say you're a New York company, and you have customers in Europe and you have customers in California. And so you may be subject to all these different types of jurisdictions. And that's a problem that we all we have to deal with in this business. So, see, next. Okay, here are the types of cybersecurity laws. First of all, you have there are laws that are straight cybersecurity laws. There are laws that are straight privacy laws, and then there are laws that basically do both. For people in the United States, there are two laws that are straight cybersecurity you might recognize. First of all, there's the New York Department of Financial Services laws. That only regulates companies that are located in New York or do business in New York that are subject to the jurisdiction of the New York Department of Financial Services. And by the way, if you are subject to the New York Department of Financial Services, please, please, please do everything you possibly can to comply with their regulations, because if there's one regulator that doesn't play, it's the New York Department of Financial Services. They will whack you with many hundreds of $1 million fine, and Now, state breach laws. Every state has one of these, and their enforcements are not anywhere as neat as the NYDFS. State breach law. Now, right now, Alabama was the last one. Every state has one. So all these states basically say that if you have a breach, you have to report it to somebody. The problem is reporting it to who, when, where, and what sort of liability you might face. In many of the states, you just report it to the Attorney General when you sort of get around to it. So, sometimes the time between you find out about a breach and the time you have to do anything about it can be months. In other places, like in Europe, it's 72 hours. And who you contact and what your liability is varies wildly according to whatever state you do business in. A lot of those states, there are 22 of the states out of 50 that have, in addition to the breach laws, they also have cybersecurity requirements. So they have a specific mandated level of cybersecurity that you have. Now, the big thing about cybersecurity laws and the standards in the world today is, what's fascinating is everyone has gone with one standard. In the old days, I'm talking about 5 years ago or maybe 10 years ago, most of the laws would set out a checklist. Thou shalt have this control, this control, this control, or whatever, and this is required. Or they'd say there's a regulator, and the regulator will come out with a list of controls. Not anymore. All the laws, almost all around the world and through many of the states, and the CCPA and the GDPR and all the GDPR copycats, and yes, there are CCPA copycat laws, all are based on risk assessment. So for those of you who aren't doing a risk assessment, that's something that is coming down the pike, and you're going to be held to the standard of it's not important as to, all information is not equal. I mean, some information like B2B information, well, back in the days, the good old days when we had to fight our way out of caves, we had things called telephone books. And telephone books had information that is, I call B2B information. It's your name, address, telephone numbers. And in fact, when you got a phone, it was very exciting because you waited and saw yourself in the telephone book. And you thought, boy, am I important. I've got my name in my telephone book. Well, that type of information isn't, shall we say, all that sensitive. All right. So your risk assessment wouldn't say, well, you got to protect that with encryption and everything else. However, as you all know, there are types of information that are wildly sensitive, specifically like biometric information and healthcare information. There is, by the way, there are things called sensitive information, which is different from under the GDPR, what's called Category 9 information. And sensitive information, it finds its way into a lot of laws in the United States. And we'll get to that in a bit. But if you have sensitive information or important information or like financial, healthcare, your risk assessment is you're going to have to spend a lot more on cybersecurity than anything else. Okay, now we have privacy laws. Privacy laws basically say, you got to keep stuff private. You can't use it unless you've got permission. And examples of privacy laws for those of you who work for public companies, in other words, your stock is sold on a stock exchange generally. The Securities Exchange Commission, the SEC, has certain rules in regard to privacy, and they were just in fact, the SEC just came out last week with a new thing on making sure you comply with their SP law, which is their privacy law. The COPA law, as you may know, has to do with children. You cannot have children online getting information. You have to get their somebody's permission before you get information from children. Okay, then there are hybrid laws. They're both cybersecurity and privacy laws. An American example is the HIPAA law, which has been around for 20 years. Of course, it wasn't enforced until it had been around for 10 years. Anyway, that is both the HIPAA is 45 CFR Code of Federal Regulations, section 164. Dot 300 is the cybersecurity, 400 is breach, and 500 is the privacy section. The GDPR, as you may or may not know, also has the General Data Protection Regulation, which is now the law in all of the EU, and for the next 6 months, I guess, in England and the UK, and that has very specific privacy laws. And there is of course, what we're going to talk about today is the California Consumer Protection Act. Now, privacy laws are a subset of cybersecurity laws. You can have cybersecurity without privacy, but you can't have privacy without cybersecurity. Why? What is cybersecurity? It's the preservation of confidentiality, integrity, and availability. If you can't protect confidentiality, integrity, you can't protect privacy. So every cybersecurity law and privacy law also, every hybrid law also has a subset of it that has to do with cybersecurity. Now, the other thing about laws is that about these types of laws, and I'll probably get into this as we go on, is there are really two types of privacy laws. There's what's called the opt-in and the opt-out. All right, that's a big difference because it depends on how a company can use a consumer's information. An opt-in law, which is the GDPR, you can't use somebody's data unless you have a reason to. There has to be a contract. They have to give you permission to use it. You have to have a law that says you have to use it, like the tax law says you have to collect information from your employees on the W-2. I guess it's the W-9. Anyway, you have to collect that information and give it to the government. So that's one of the reasons that allows you to use a person's information. Now, there are also opt-out laws, and this is what the CCPA is. The CCPA basically says, oh yeah, you can use anybody's information you want. However, you have to give them the right to opt out. You have to say, look, you know, if you don't want us to use your information, you send us something or contact us in some way, and we will get rid of your information. It's a major difference because what the GDPR really is, when you think about it, it's a property law. What it does is it says my data is my data, and Mark Zuckerberg or anybody else can't use it like, you know, like my car. My car is my car. Mark can't come in and use my car unless I give him permission, because that's my car. Okay, the same is true with data, is that's my data, and you can't use it unless you comply with the property rights that you have in that specific data. And basically, that's what the GDPR defines. Why is the GDPR important? Because Cisco, Microsoft, Apple, and even Facebook have all stated that they want to have an American version of the GDPR. And there are like 22 draft laws presently making their way through the Congress sausage mill, although I don't think any of them will get out, many of whom track and use various similar types of languages to the GDPR or other types of privacy laws. Okay, here is a list. We were talking about the various. Said a little bit about the European laws. Well, let's also talk about the U.S. state laws. So here we have different types of state laws. Now, the U.S. operates according to what they call a sector law. So rather than a general law, like the GDPR applies to every type, every institution. It applies to the Parliament in the UK. They have to comply with GDPR. It applies to government institutions, like they have the National Health Service, which is their version of their version of like Medicare. So they have to comply. It's like if the VA hospital in this country had to comply with privacy laws. That's not true. In this country, it depends on where you are and what you do. So, for example, let's start with state laws. Now, everybody in this country has to comply with breach response. There are some states I probably have exemptions, but most states don't. So no matter where you are or what you do, you're going to have some sort of breach response procedure. Now, admittedly, the probability of having a large fine for failure to report a breach is probably not great. However, that doesn't mean you shouldn't try to comply, or it's even better, you should have a response, not to necessarily protect yourself against laws, but protect your company. And I also want to state, to start off with, that the reason that we do all these things has very little to do with law. Like, for example, unless you are a large, unless you're a huge big tech firm, the probability of you getting fined under the GDPR is 0.9%. However, the probability of getting into trouble under the CCPA is probably far greater. Okay, and why? Because, you see the next section, 22 states have cybersecurity requirements. Okay, now that means that you have to comply with those security requirements. What are the security requirements? Most of them have to do a risk assessment. You have to determine what information you hold, and then your duty. It's like your duty driving a car. If you do business, and collect information, you have a duty to your customers. If a customer comes into the store, you don't want to have a situation where they slip and fall on a banana peel. You don't want to drop a big safe on them. You want to make sure your premises is safe. And that's true if you collect their information. You want to make sure that their information is safe. I mean, yes, you have to comply with the laws, but it's basically more for your business. Remember, this is about law, but it's also about your business. because most of my delegates are always very, very high quality, very smart. Love teaching them. IT people, and they have sometimes difficulty communicating with their board. And as I tell them, information is not ancillary to your business now. It is your business. You cannot do this without good information protection. And that's one of the reasons we have to have cybersecurity and probably privacy. Now, certain public companies, in other words, that means that your shares are owned not by a small group of people or say a private equity firm, they're owned possibly by the general public. And the SEC requires that you have certain privacy requirements, and there's also a private firm called FINRA, which also has certifications. Then financial companies, that has to do with FINRA. And of course, I mentioned the NYDFS. And then again, in healthcare, if you are involved in the hospital, healthcare, or you're affiliated, or you're doing something for a hospital, then you're probably covered by HIPAA. So those are the US security laws. It's very complex. At the GDPR in Europe, you just have one law. That's it. You don't have to think about what you do. It doesn't matter where you are. It doesn't matter whether you're government or non-government. That's it. In the United States, we're sort of all over the map, literally. So it depends where you are, what you do, and things like that. It's a complicated. You really couldn't have, if you tried to build a bigger mess, you couldn't have done it. Anyway, so what laws apply to you? Because that's what we're interested in. I don't do business in Europe. Why do I care about the GDPR? Well, of course not. So what you have to think about are two types of jurisdiction. In other words, what law covers whatever you do. And there's sort of two types. There's territorial and material jurisdiction. Okay, territorial is just what it says. It's pretty obvious. Are you in a particular place? Are you within the borders of a state or a country? But there's also something to remember, that laws stop at borders. All right. Now, if a country or a state wants to protect its citizens, they have to, from things that could happen on the internet, they have to come up with something a little better. They have to say, well, if you're doing business in this state and you are doing business with our citizens, then our law applies to you as well. And that's territorial. Now, this is not unusual. This has been the law in the United States for, probably the last 150 years. If you do business, if I'm like a Massachusetts corporation and I do business with people in New York, I'm subject to New York's jurisdiction as to those people. So that's pretty standard. So the point is, the reason why this is important for most of you is that California has like 12% of the population, about the same amount of our gross domestic product. So it's pretty hard to be any size of a business without doing business with possibly somebody from California. And if you do business with somebody in California, then you're subject to this law. Now, there's probably more European businesses doing business with the United States and the other way around. So there are actually not that many, maybe 50,000 US companies whose operations may be subject to the European law, the GDPR. However, there are many more, there's twice or three times that number, who do business in California. And so they definitely might be subject to the California Consumer Protection Act. So the impact, at least in regard to US business of the CCPA, is probably going to be a lot greater than like the GDPR. Okay, now we're going on to material jurisdiction. So not everything, the law doesn't cover everything that you possibly could do with information. It's very specific. What it does, it just covers what you do with the information. Do you just process it or do you sell it? That's a big question under the CCPA. Because if you're like Apple and you say, I'm not selling any information, we're keeping it, and you get Tim Cook on that, basically saying this is why you ought to have Apple, because we don't sell your information. That's, that makes a major difference. That gets you out of the California, a lot of the requirements of the CCPA. Okay, it also depends on who you are. In the last slide, we went over healthcare, financial firms, or maybe you're just a cloud processor. All right, that comes under different things. Like, for example, if you're a cloud processor, you might be exempt from a lot of regulations, but if you do business with the government, you might have, then you come under their regulations, FedRAMP. Okay, there are also occasionally under the CCPA, there are exemptions as to size. So if you're a little tiny business or you don't do any of that, then you don't have to worry about this at all. You're out, go home, do something else with your life. Okay, now also as usual, all these laws everywhere around the world have exemptions for military, police, and certain other types of security services. So those people, or if you're acting under the direction of a government entity, if you're a contractor for like the military, or you're a contractor for the police, under those situations you might have different requirements in terms of security or privacy. You might be out. Now, as I was telling you, these laws are everywhere now. So this is an example, it's just a sample. These are only 8 countries that have adopted something similar to the GDPR. However, this list is old because these things change so quickly. So I would guess there's probably about 20 out there, and they have adopted various versions of the GDPR. So wherever you're doing business on a global basis, not just doing business in the United States, which is also impacting everything you do, this is something that you have to think about in terms of your regulatory environment, because this has totally metastasized, and over the last 2 years it's gone nuts, and everyone's got one now. Okay, now for California, let's start. Remember we talked about territorial jurisdictions. Okay, now if you do business in California, what does that mean? First of all, with territorial jurisdictions, if your company is located in the state of California, if you have an office in San Francisco or San Mateo or, God forbid, Bakersfield, you are a subject to the jurisdiction. So you have to comply with the thing. Now, it's a 2-step process. Let's say you're outside of California or in California, either way, it doesn't matter, but you process data of a California resident. What's a California resident? Basically, it's somebody who pays taxes in the state of California. It's whoever California thinks is a resident, which is sort of a complex question. But if you have customers of some sort, or partners, or you process information, or whatever you do, let's say you have a data center in California, which I'm sure a lot of you do, might have some contact, what they call in the law a nexus between you and the state of California. You could be subject to this particular law. There are also a lot of things. However, there are other things. This is not the universal requirement of a state breach law or the GDPR. There are certain types of companies that don't have to do it. So it has to do with what you do and the size. First of all, you have to go through these questions. Does your company collect or sell information of a, quote, a consumer? Now, a consumer of the law is a California resident. So if all of your customers, and you're sure about that, are in the state of New York, you don't have to worry about this. That's not your problem yet. Don't worry, it's coming to a neighborhood near you. Okay, now California also doesn't want to put a big burden on small businesses. So basically, they also say that before you're covered by this law, you have to have at least $25 million in annual revenue, or unless you're a small company, let's say you don't have $25 million in revenue, but your business is crunching, personal data of California residents, and you have personal data on at least 50,000 people. then even though you might be a small company with revenues below 25 million, you're still subject to the law. Or let's say you're a tiny company. Anyway, you don't have 25 million, you don't have 50,000 records of people, but you do crunch data. So you're actually a data broker, and your company's involved in half your company's revenues come from the sale of personal data. Well, it doesn't matter how many of those you do. You could be much less than 50,000. Your revenues could be far less than 25 million. But since you're in the business of selling personal data of California residents, remember this is a two-part thing. You start with this, and then you go down this checklist. Then you're under the law. Performs any set that are performed on personal data, and you have to. It has to be an automated means. In other words, you can't be like a filing system. So you have to use computers, which I think is just about everybody. So that's type of thing. Okay. So what you do is you go down to your list and see where you fall within the whole process. Does your company have over $25 million in revenue? Yes, no. Does your company have processed or store information of over 50,000 people? Yes, no. Does your company make over half its data? Okay, yes, no. And does it involve California? Do you sell stuff to California residents, or do you collect information from California residents? This is where another idea you might want to think about is data mapping as well, along with risk assessment. But the problem is, if you got information, if you got your data floating all over the world, you're floating through a lot of different jurisdictions, and it might be a good idea to figure out which ones apply to you. But this is your step process. This is the walkthrough you want to go through to find out whether or not your company is covered by the CCPA. Now, let me also say that this is changing very rapidly, because Congress seems to be unable to do a lot of things these days. What's happening is the states are stepping in. So they're coming up with all sorts of different types of laws. And these things aren't new. They've been around, some of them, like Massachusetts law, has been around for 10 years. So, there's not only one CCPA right now, there are 5 that are being considered by various states throughout the country. And then, of course, there's Washington State, which is basically going the other way. Rather than adopt the CCPA, they're thinking of adopting a local version of the GDPR. So we're having a lot of experiments in these states. Now, hopefully what would happen is we'll get one statute which will, have supremacy over all the state statutes out of Congress, but I wouldn't hold my breath. So for at least probably the next 2 years, or maybe longer, we'll probably have to deal with different types of states having different types of laws. So you better think about where you're doing business. Okay. What type of information are we worried about? What do we want to have being private? Now that varies enormously depending on what laws under which jurisdiction. Now the general concept is that's more global and accepted more generally is the GDPR definition, and that is personal data that allows you to identify or identifiable. I mean, that's stuff like your name, your fingerprints, your iris, your where you live, but it could go far beyond that. According to Facebook, if you have 70 likes, you can identify know somebody better than their spouse. So that could be identifiable information. In Europe, for example, DHCP address and things like that are considered PII. That's not true of the United States. There's 2 different standards between the 2 countries, but that's one standard of what is considered privacy. Like, for example, if you just have information about who as the number of people who have measles, and you don't give them names or anything that I can identify these individuals, then that's not personal information. You don't have to worry about that. Okay, now under the CCPA, that's very similar to the GDPR. That is information that identifier relates to or is capable of being associated with, could be reasonably linked. Now notice something else here though. It says with a particular consumer or household. Whoa, I said they said that may be subject to change. They may delete household, but for now, I mean that includes your dog, for God's sake. So that they've really increased the number of people that information you have to think about in terms of what exactly is personally identifiable information. Now, just to make things more complex than they already were, states, in terms of deciding what sort of stuff they want to regulate, have just they've said, oh, what the hell? Let's come up with a checklist. And these checklists, interestingly enough, are fairly uniform. So there's types of things you normally think of, like there's social security number, your driver's license number, your financial information, your health information, your race, religion. That is they consider personally identifiable information. So like your name, your telephone number, your email address, your address, that type of thing that used to be in the phone book is not considered what they would call sensitive personal information. In some states, if you lose that, they don't care. All right, it doesn't bother them at all. But you have to consider, the problem is because the legal and regulatory environment is so, shall I say, it's screwed up, that you have to consider that in terms of types of information you collect or you may have in your system. So it's a pretty good idea to consider doing a inventory of the data you hold. Okay, now, all right, you've got all this information, you got this stuff. All right, what do you do with it? What do you have to do with it? All right, well, all these laws, the privacy laws, are divided into, have two types of things. There's the duties companies owe and the rights that consumers have. So one major duty that all these laws have almost in common is they have a right to know this one. They have the right to know what information you collect about them. And the way you deal with that is in your privacy notice. Now, there's a lot of misinformation about privacy notices. When the GDPR came back, all our email boxes were filled with notices. Then we just changed our privacy notice, click on this link and go look at it. And you looked at it and there was something that was 5,000 to 7,000 words. And of course you didn't touch it because it was too long. It was weird. I didn't read them. Well, I read some of them and they're insane. That is the wrong way to write a privacy notice, because what's going to happen if you have a 3,000 or 7,000 or even 9,000 word privacy notice, you're going to have something in that privacy notice that it says you don't do when you're going to be doing it. In that case, you don't come in under privacy laws, you come under the jurisdiction of an FTC law, which is Fair Trade Commission, which has been the law in the United States since 1905 or something. And there's also state laws on unfair and deceptive trade practices. So your privacy notice, you have to be very careful. You have to make sure you say what you do, and you have to be sure you do what you say. All right, that's really, really important in terms of the categories of information. You have to say, this is what we collect, and this is what has been sold or disclosed. Now, all of these laws have these requirements in them about privacy notice. So that's part of your global compliance bit, okay? You have to be very careful about how you put together your privacy notice. And if it's, I'll tell you right now, if you've got a privacy notice that's more than 1,500 words, you're doing it wrong. It's just, you're going to get in trouble. Maybe not. I mean, for both Google and Facebook are under consent decrees from 10 years ago, and both have violated them. They could be subject to some real whoppers of fines because the violations are based on the number of records. So, it's like $100 a record and there are millions of them. So anyway, but that's one of the main things about global compliance is your privacy notice. Very important. Okay, the second one, consumers must have a method to access information collected about them. Okay, that's universal. So the two things you got to worry about everywhere is your privacy notice and allowing your data subject, your consumers, whatever you call them, to have access to their information, or at least a method that they can find out how much information you hold about them. This is those two things. If you get those two things right, you're probably 90%, toward global compliance. I mean, you have to adjust them according to your jurisdiction, but those are the biggies. So the right to know what information has been collected about them. You have to give them a method to find that out. Now, they should know what information you collected on them because you told them. You told them in your privacy notice. Don't get cute. Just don't. You're going to get in trouble. Don't get cute. Okay, when I get to the penalties, I'll tell you how you're going to get in trouble. All right, now consumers have, this is under the CCPA, mind you. I'm just saying that these are sort of universal, but these, as you see the statute numbers right there, those are all the statute numbers. These are the requirements of the CCPA. You have to tell consumers what information you have about them. You have to give them access. If you sell their information, they have a right to stop you. You're not going to do that. Also, unlike the GDPR, you have a right to delete. A consumer has a right to delete information. So, for example, I'd have a right to go to Google and say, just delete every little bit of information you got on me. And Google will say, well, I'm gonna hurt you for that. And so you go back, no, you're not, because you can't discriminate. So don't play with me anymore. I mean, definitely the pitch, as they would say in the UK, the ball field has changed in terms of who's got power. Okay, this is your notice provisions. Now, these are the notice provisions under the CCPA, but there ain't, any privacy law out there that doesn't have something similar, and it's required. Just be very careful how you draft these things, and not 2,000 words, please. It should be very clear. You should have links, anchors, links to whatever you're talking about. So you look at like a list of 10 things of links, and then you can go find things you want to figure out. But this is what you need. Don't, look at the list. Make sure everything's in there. Don't, go on and say, well, I'm going to tell you about how wonderful my product is there. Oh, no. You put that in another section of your website. There is a problem with this in terms of notice, because I had a delegate who worked for a very large company, and they had many websites. And there was a question about, what you should put in your privacy notices for different websites. And just tell people what you do. Do what you say what you do. And you have to be very careful about that, because you don't want somebody from marketing going crazy, because they might be doing something that's not in your privacy notice. So be very careful. Now, the big thing under the CCPA, which doesn't exist anyplace else, is on your homepage. After this thing does not go into effect until January 1, 2020, so you have like 8 months to go. Make sure you have something that says, do not sell my personal information. Click, because I have a right, if I was a California resident, to go on, or if I'm doing business with a California company, to go on the website and find the big red thing, click on it and saying, don't sell my stuff. And that has to go directly into your records, into your database, into your whatever, and they have to be, it's like on the no call that you cannot sell that information once they click on that. Okay, or they have a right to delete the information. Now that's absolute. That's different from a lot of the GDPR ones. Under the GDPR, you don't always have that right, but under the California law, everybody gets it. It's subject to this. Okay, here are some of now to make life worse. Not only are there different laws throughout the United States, but the California law is written like the tax code. One law doesn't, refers to other laws. So most of the laws are in one place, but there's some other laws that are other places. And these actually aren't quite new. They've been around for a while. For example, the breach notification law in California is not part of the CCPA. It's in a different section. Interestingly enough, right now, the CCPA only punishes people for failure to breach. There are penalties for failure to protect privacy, but they're different, and that might be changing. So we always have to be careful of that. So there are also other things about transfers to third parties. which are different sections of the law. So you have to look in different areas. It's definitely not, clear cut. So anyway, we went over a little bit, and in terms of what sort of security people have to provide. And this, again, has to do with very common definitions, and that's the definition that requires, shall implement, and maintain reasonable security procedure appropriate to the nature of the information. What does that mean? Risk assessment. What information do you have? What type of things do you want? This is also a good time to think about getting like an ISO certification, because you can save big bucks on litigation if you have an ISO certification. Why? It's not that the NIST CSF is better or worse. It's just with ISO you got a piece of paper, so you can go to court and say, yeah, here, judge, here's the piece of paper. We're complying. We've done our job, and you get out of court at that point. So it's something it could be a biggie. Okay, what sort of breach notification? What sort of breach notification do you have to require? Well, again, this is all over the map. Under California law, you have to provide notification to those customers or records you've lost as soon as possible. GDPR is 72 hours. Some of them are like 3 months. It varies. There's also usually a breach, an exception for loss of information over 500. If you lose over 500,000 records, then you can use something called substitute notice. You can advertise in a newspaper or on the internet or something like that. But you have to understand that every state has one of these, and it's not just the CCPA or the GDPR or something like that. Every state has one of these, and you have to think about where you do business. Again, your data mapping tool. And then you think about that and make sure that you have a procedure. You should have a procedure anyway if you have nothing else. Okay, transfers to third party. This is the big no-no. This is the problem. This is the no-no for the CCPA. This is what the CCPA is all about. It's also part of the GDPR. You have to provide notice for that. And there are ways of getting people to delete that, but this is a big one. In the CCPA, you have to provide, if there is information for transferring to third parties, they have to be able to prevent it, any transfer. You have to respond within 30 days. You have to have notifications on your privacy rights, and you have to provide the specific information required by the statute, which I pointed out in an earlier slide. Okay. We're going to talk quickly about the penalties. Okay, the penalties, the problem with, we all thought that the GDPR was up to 4% of your global revenues, or 20 million euros. Oh, that's big. No. It's a lot bigger in the United States. And it's not that, because there are two types of state penalties. One is something you really probably don't have to worry about. That is the Attorney General fines. Why don't you have to worry about? Well, it's because basically the Attorney Generals are usually too busy to get around to you. Now, that doesn't, it all depends on your Attorney General. You might have a really active Attorney General that wants to hold your feet to the fire, and at which point you better be really careful. There are others which are saying, I don't know nothing about IT. I use a computer, but that's for propeller heads. So, I'm not going to bother with it. So it basically, under Florida, it can be very, it's discretionary. They don't have to give you a fine at all. They just determine if an enforced action serves the public interest. So that's like, it's like the Mueller report. Do you have to prosecute? No, you can leave it up. That's up to the prosecutor to figure out. However, there is something called a private right of action. What's a private right of action? Private right of action gives the citizen the right of actions to bring a civil action for violation of the statute. So under the California, right now the law under the CCPA doesn't grant that. However, there is an amendment that's backed by the Attorney General to amend the CCPA to give people rights, as a private right of action, to sue in court. Anybody can do it, to sue in court for a violation of privacy rights. Now, so far, these class actions have not been successful. And it's not for lack of trying. There's tons of them, but you haven't seen any. A lot of cases, you haven't seen any real major settlements out of these. Most of the damages that have come out of these type of cases, breach cases, have come from legal fees, which is why it might be a good idea to get certified so you get out early. So anyway, however, there's a problem. There's a U.S. Supreme Court called Spokeo. And to bring an action in the United States, you have to have damages. Now, what happens is if there's a breach, quite often the person, let's say somebody gets 10 million credit card numbers. Well, you know, if the cyber thieves are successful in monetizing that, usually the people who have been damaged by federal law, their damage is limited to $50 if there's a problem with your credit card. And often they don't even pay for that. The damages are taken care of by the credit card company, MasterCharge, by the banks, or by the retailers. So there is no damage. And the Supreme Court has said no damage, no case. So you can't go in and sue people for breach of private action because so far there haven't been any damages. Well, under the California Consumer, there are statutory damages. So there's $100 for violation of the statute. You couldn't get $100. Well, who cares? Well, multiply $100 times the number of records lost. Let's say you didn't have a bad breach. Maybe you lost 1 million records. Time $100. We're talking some real money here. Now, it's a class action, so they can include all the members of the class, and of course, in the United States, we have contingency fees. So they don't have class actions, they don't have contingency fees in Europe. So that means under these statutes, potentially, it's not there yet, but potentially, the penalties under this could, be astronomical. So this is something you have to take very seriously because it's not there. With the right of private action and combined with a class action suit, combined with mandatory damages, means somebody's going to court, and some of the damages could be far worse than other types of things. Okay, now in addition, the CCPA. Right now, there's only class actions for a breach. There's also, a lot of these laws also have mitigation factors. Like the GDPR has 11 mitigation factors, and the CCPA right now, which might be amended, we don't know until this goes into effect in 8 months. And again, no attorney knows anything until a judge tells them what something means, and we don't have a lot of case law on this. So this is everything I'm telling you right now, or a lot of it. I don't think there'll be major changes, at least in the privacy section, because none of the amendments, and there's 11 of them, potential amendments in the California legislature right now, none of them really impact the privacy. Anyway, in addition to the right of private action, the Attorney General can do all sorts of things. They can fine you for up to $7,500 for each violation. That's every record you lost. If you're really sloppy with your cybersecurity and you are what they call reckless disregard, it's called gross negligence, then yeah, somebody can whack you for $7,500 per violation. So, that can add up to, even if you lose just 1,000 records, that can add up really fast. Now, I'm not sure if they're actually going to do that unless it's a terribly egregious case. Okay, right now they can interview that stop consumer action, but I think they're giving that one up. They're saying we're not going to bother with that. Violation, there's also, they give you, under the privacy sections, they have 30 days to cure. So if you don't, let's say you didn't give a consumer their information, they asked you not to sell the information, you did that, that type of thing. Well, right now, as the statute stands, you have 30 days to reverse the process or you'll get whacked. It's another mitigation factor. So they basically giving you an out. Under another law, for example, in Ohio, most of these states go off on negligence. In Ohio, if you have a cybersecurity framework like ISO 27000 or NIST's cybersecurity framework, and you in that's per se not negligent. So that's an easy way out of the statute. Another way out of the statute is to make sure all your data is encrypted or de-identified. So there are other ways to get out of the statute. So if you want to protect yourself, there are ways to do it. This is not, doom and gloom. I mean, complying with all these laws are quite possible and actually not unreasonably hard. It's going to take some thought, and depends on what size company you are and where you do business, but there are ways of adapting your situation to this. So anyway, here's your right of private action. That's your damages there, $100. And that basically times per incident, which is per record lost. So that can be real money. There's also injunctive relief, which could be worse because it could say, well, you can't do that anymore. So, you're out of business. Of course, there are mitigation penalties. And again, of course, this is in the United States. So if you can have two laws on the same subject, go for it. So not only do you have the CCPA, you've got the records penalty as well. So you have two bites of the apple. Okay, now to finish things up, since my time is almost up. So what we're going to do is these are the various types of ways you can adapt to this. My favorite is ISO 27000 because remember 75% or something like that, about 60% of the actions are brought on negligence. In order to avoid a negligence action, you have to prove that you were fulfilling your duty. So like when you drive a car, you have a duty to other people on the roads to drive the car safely. And that means not texting or talking or something like that. Now, in cybersecurity, if you can prove easily that you have subscribed to the top international standard, then you basically you're not negligent. You can say, look, now the problem is with a NIST standard. There's nothing wrong with a NIST CSF standard. The problem is it's difficult to prove. So if you say, well, look, Judge, we're compliant with the NIST standard, CSF. The plaintiffs are going to say, prove it, show me. And the judge is going to say, all right, well, that's a question of fact. So let's go on with the trial, guys. But if you can come up with a piece of paper and say, look, Your Honor, here's our piece of paper. We've got the highest standard. They could give you a motion to dismiss right there and you'd be out of court. So you'd save yourself some of the highest levels for the highest costs associated with litigation under one of these private action lawsuits. Again, what you're going to have to do is all the laws now are risk assessment based. So risk assessment is going to be very important no matter what you do. And it's just a good measure of cybersecurity. And then you also might want to consider a data mapping tool so you can figure out where your information is. And this is a word from our sponsor. This is I'm putting together right now a training course for the CCPA, which should be ready at some point in time in the near future. And also the other thing you have to think about is we're also putting together a course on global compliance in order to hopefully have a one-size-fits-all and work with that. Okay. Now, thank you very much for your patience. And my time's actually up. So, sorry about that. So, I'm not sure if you got any questions. So, if you want to, you can always send them privately or respond to that, or you have about a few minutes to ask any questions that you so desire. Other than that, you can go and send them over. Okay, oh, wait a minute, there is a question in there, sorry. I think the materials are available. As far as, I'm sorry, I can't. It's difficult for me to get into, they're not showing the questions very well. Okay, I think the question is, the GDPR does not have opt-in requirements. Oh, the opt-in requirements. The GDPR's opt-in requirements are found in Article 6. You have 6 methods of allowing you to use somebody's information, or allowing, basically it allows the data subject to opt in. Those, you can only use 4 of them. The first one, the most obvious one, the general one everybody knows about, is consent. The second one is contract, if you have a contract with somebody. Third one is the government requires you to use the information. That's like the W-9. You know, the government says you get that information that allows you to use it. And the last one is the big one that everyone loves, and that's legitimacy. That's very something you can do, but it's something that you have to think about in terms of asking for it. The materials, I believe, I said that the materials are available. What's the best way to handle CPA's opt-out requirements in conjunction with GDPR requirements? The best way is to, in terms of, is to basically you want to comply with the higher standards. So the best way to do it is to find out a method by which you can use somebody's information, and the best way to do that is utilize Article 6, A, B, C, D, E, F, legitimacy. You can use the legitimacy, and that's pretty general. And then basically you put that in there, but you also have to provide a methodology by which it's very easy under both statutes, and you comply with both statutes, you're good. But then you have to have a very good way to allow people to get out. So if, let's say, for example, you're using information that you shouldn't under the GDPR, or you're using information that the person wants to opt out of under the CCPA, just make sure that you have an easy method for your consumer, your data subject, to delete your information. You can comply with both these laws very easily if you have a policy and procedure that allows the consumer to wipe your records clean. If you can allow these people to get out of your database, you're in really good shape. And if you make these people happy, they're not going to complain. They're not going to sue you because they won't have a basis for doing either. So then you won't get fined. Just make sure that you have that basis. Nonprofit association. Ooh, I don't think the CCPA applies to nonprofit association. The statute, the definition of a business, which is 1798.140, and I think it's C, says organizations organized for profit. So I don't think profit is a requirement for jurisdiction under the CCPA. Let's see if I can read any of these others. Copy of the recorded webinar, you'd have to ask the people at, I believe they will send them if you've registered for these things. If you've registered for those things. Let's see. Gosh. However, we might be collecting information of California residents as a part of booking tickets with, yep. Okay, does the CCPA? Yes, it does. If you are collecting information, if you're collecting any information about a California resident as a result of booking information, yeah, the CCPA would, because you get the information. Slides available in print. Okay, their slides should be available. I believe what they do, or what they've done in the past, is let's see. I'm with Global Airline Company. We have a small office in California. Bingo. That's it. If you have an office in California, if you have an office in France, you're subject to French law. If you have an office in California, you're subject to California law. Is this for territorial and material jurisdiction? Well, you have to think about both. If let's say, for example, you have an office in California, but you only, for some reason, you only process information of Japanese citizens. It doesn't matter. You're still in California. You're subject to California law. If I kill somebody in France, I'm going to get tried under French law, not under New York law. So either one will get you subject to their law, depending on what you do. Remember, they have the material jurisdiction. They do customers because laws stop at borders and the internet doesn't. Okay. That was fun. So anyway, if you've got any questions or if you want the materials, I will question our home people and find out what they say. And hopefully there should be a method of getting that. I believe what they do is they send them to everybody who is registered. That's my understanding. Other than that, you've been very patient, and I'm over, of course. Just keep I know most of you are probably IT people, and I'm it's really annoying to me that among all the other major, very smart people do, you get stuck with this. But you know, you've got to keep you've got to have situational awareness, because this is happening very rapidly, and make your job is not necessarily for you to do it, but get other people in your company to help you out, because you have to make sure that your senior management knows that you know, this is everywhere now. You can't avoid it, and you have to rethink how you're doing how you're doing business, and what you're doing business, how you're doing business. This is not necessarily that onerous. You can do it fairly easily, and there are a lot of people like Microsoft. They look at an Apple. They're looking at a business opportunity. So it's not, you know, it's not all bad. Protecting people's stuff is part of your brand, and if you do it well, you have a competitive advantage. So anyway, well, thank you very much, and there will be other webinars as we go along, and have a lovely rest of the day.